So these are the committee reports, family law, legal aid, and real estate. We don't have any presentations, do we? No, okay, so I'm gonna start since I sat down first. From the family law perspective, it's been a relatively quiet 6 months. We've continued to meet with the LSO Family Law Roundtable. Logan's going to get more into that. That's an access to justice initiative that seeks to bring stakeholders together and brainstorm ideas and see if they can be given any legs. One example of that is family law clinics as articling positions, which seems to tick 2 boxes. The next meeting is on November the 9th, so we'll have more to discuss at the next plenary. We have a meeting coming up with MAG to talk about the Ontario Court's digital transformation, specifically as it pertains to family law. That we'll report back on that in June. And then one issue that I want to raise, but I want to make sure that my experience is consistent, is the issue of regular motions. So in the old days, we used to, at least in my jurisdiction, pick a motion date. In my jurisdiction, it was Wednesday and Thursday, put that on our notice of motion and set it. And you'd appear on that day, the judge would have 40 matters on the list. You may or may not get reached. You may or may not have a backup judge that comes in to assist. If you didn't get reached, you just picked sort of the next day or the next week. Now what is happening is you have to book a regular motion, and the powers that be look at the list and say, well, there's 15 minutes on this day 3 months from now. And from a family law perspective, we have this gap in terms of motions that are urgent, which get dealt with, versus motions that are pressing, which don't get dealt with until sometimes they become urgent. And I spoke to my LAJ about this issue, and he sort of said, Ms. Oliver, I don't really feel sorry for you. They're scheduling 7 hours of motions in front of us, and I don't know what more you want me to do. And it seems to me that the presumptive mode of appearance is impacting the judge's ability to wade through 7 hours of a motions list. And so it may be that the mode of appearance may have to change so that judges can deal with more motions. But, in my mind, in response to the I don't feel sorry for you, Ms. Oliver, was, I don't feel sorry for you either, Justice so-and-so, because you have a job to do. And the stats show that the current level of cases before the court have not returned to pre-COVID levels. So it's not a matter that the judges are overwhelmed with many, many, many more new cases. It's that I think that the technology and the mode of appearance is just making it more cumbersome and time-consuming to deal with simple motions. So I'm putting that out there. I would love to hear from everybody if they're experiencing the same problem, because I do believe that it is an access to justice issue for our clients. And if everybody's experiencing, or most people are experiencing the same thing, I do want to write to Justice Stevenson about it. And I will turn it over to Logan.
Thank you, Laura. So good morning, everybody. It's great to be here in Hamilton. And I don't just say that because Hamilton is now my home city. Yes, the rumors are true. Between the last plenary and now, Hamilton has become my home city. And no, before you ask, that's not the reason why we're all here in Hamilton today. And as you all, in the roll call, we heard directly from the horse's mouth what the real story is as to why plenary is in Hamilton this time around. And I'm not in any way, shape, or form suggesting that Mr. Keesmaat resembles this remark in any way. Now, on the last occasion at Spring Plenary 2024, I mentioned how in recent months there's been a bit of a less of an emphasis in our role, Laura's and my role, in making submissions, written submissions, simply because there's just been less of a call for them in the last year or so. I personally really enjoy drafting submissions, so I'm sort of secretly hoping that some more opportunities may present themselves in the next 6 months. But I mentioned last time how this, in my view, would allow for more bandwidth to work on some self-initiated projects. And as Laura said, it's been a bit of a slow 6 months from my perspective as well, and getting the ball rolling on some of these items. I will personally admit it's been a little bit more slow going than I had hoped, but there's a few issues that we discussed at the last plenary, such as the increasing role of AI and technology in the family law realm, and we discussed some of the issues that practitioners have been facing and continue to face in that area. And just on that subject, there's a number of people in this room. For those of you who are practitioners, I know that we have a diverse field of stakeholders, but for those that are practitioners, can I just get a show of hands? Whose practice either involves exclusively family law or touches some family law? Can I just get a show of hands? So we don't have an ability to get the camera to sweep around the room, but it looked as though almost everybody's hand went up. And so family law is an important issue, of course not to the exclusion of other areas of law, but it's a very, especially for the Main Street lawyer, it's an area that a lot of practitioners touch upon. Now, back to the technology issue. Last time I mentioned that one of the specific pain points for practitioners on that piece is the government mandated forms, which are very difficult to use. And back to self-initiated projects, this is still a project that I'd like to keep on my radar. What I will say is that after the last plenary, Laura and I received quite a bit of interest from stakeholders that were at the spring plenary, which prompted us to get the idea to start what we've called an ad hoc family law committee. And we haven't been able to make much headway on that yet, unfortunately. But for those of you who did reach out, and there were a number of people, we haven't forgotten about you, I just wanted to say. And we'd like to get back on the horse to get that running. But after reviewing some of the responses that we did get, we sort of reached the conclusion that it'd be best to have FOLA potentially reach out to the associations for a family law volunteer. This is actually something that Laura spearheaded, but we haven't been able to make much headway on that yet. But to reach out for a family law volunteer within the associations to see if there is such an interest within each particular association, and then get an initial Zoom meeting set up to discuss initial items. So again, after having some discussions at our last plenary and having some internal discussions within FOLA about this, it's looking like that's the route that we'll go. So for now, I'll just say stay tuned for something coming down the pike shortly. To get the ball rolling there. Now, in terms of more direct activities, one project that both Laura and I have been involved with has been the Family Law Roundtable, which was spearheaded by the Action Group on Access to Justice of the LSO. And we had what I believe, and Laura did touch upon this, but we had what I believed was a very productive meeting in June of this year, in which we discussed a number of topics that require attention. And what we did was we divided up the issues into various subcommittees. And just briefly, there's a subcommittee that will be looking at the review of the rules of professional conduct. There is the Virtual Family Law Information Center, or FLIC, Virtual FLIC, subcommittee that Laura is a part of. And there's the subcommittee involving the issue of challenges regarding articling students in family law and whether legal clinics could play an increased role there, which I am a part of. And then, of course, there is the always hot topic of paralegals in family law, and around that we have the subcommittee on the Family Legal Services Provider license, or the FLSP license. And since the first cohort will be commencing at Fanshawe College in January of 2025, that will be reviewed, and most likely it's a bit too early to tell at this stage how this will all play out, but it's certainly an area worth monitoring. And last but not least, we have the Open Courts Subcommittee. Neither Laura nor I are a part of that, but when it comes to that and the other subcommittees, I can say that really, if you look at who's part of them, it's a veritable who's who of the family law community. I think that the subcommittees are in very good hands. Some of them are in this room, actually, and or at least some of them will be if they can beat the traffic. As Laura mentioned, we're next scheduled to meet again as a full group on November the 19th to report back on the various subcommittee efforts. So likely further updates will follow once the efforts of the Family Law Roundtable continue.
Yeah, the only thing I wanted to add is on this issue of delay, my email is laura@russolaw.ca. Please reach out to me.
Yes, no, thank you very much, Laura. And you mentioned delay, you mentioned access to justice. We've been saying for some time now, at least I personally have been saying for the last 2 years, that the top 3 issues in my view are access to justice, consistency, and delay. And I would continue to believe that to be the case. And like I said before, Laura and I have actually gotten quite a decent amount of feedback from practitioners over the last year. Again, regarding the Family Law Committee, there will likely be something coming down the pike soon from our end. But we always encourage those with suggestions, feedback, or just items people wish to bring to our attention to send an email to Laura, myself, or certainly just CC both of us. And our email, I believe, can be found on the last page of the plenary agenda. I'll just add as a concluding remark from my end that I'm looking forward personally to assisting with the moderation of the Reclaiming the Best Interest Lens for Trans Children program, which is tomorrow, Friday at 11 a.m. So be sure to stick around until the very end of our program, up to and including tomorrow. There's really a lot of very interesting and important content that's up ahead. So unless you have any other concluding remarks, Laura, that's all we have from the family law perspective. And next I'll turn things to Mark Giovanni for our real estate update.
Thanks, Logan.
Yep.
Yes.
Do you have any updated information about the Unified Family
No.
Court that's been promised for
No, there's no update.
It's a bit of a running gag, for lack of a better word, that we have, is that it's bad luck to bring up the UFC at these updates, because it just seems like every time we seem to get closer and closer, we seem to get further and further away from a resolution. And I'll just say this, I got some very mixed messaging at the Family Law Roundtable as to what the status of that was. Many of us are hoping for more substantive updates on that, but it just seems that the closer we seem to be getting, the further we get from it. So in a like manner to what I used to say about the about us in Halton getting a new courthouse, I always used to say, I'll believe it when I see a shovel in the ground, and I would say something similar about the UFC. Yeah, well, the shovel went in the ground, but they didn't actually turn up any dirt.
Yeah,
so.
Yeah, so every time we sort of go back and try to get more information, we are told, no, your information is incorrect. So I don't know what the update is. Mark?
Well, welcome everyone, and real estate, here we go. So I know that either you or people in your associations have a real estate practice out there. Whether it's 90% of what they do, whether it's 5% of what they do, real estate impacts everybody's practice in some way. And in other ways, it's also a barometer for what else is happening with your clients. In many cases, that's the first instance that a lot of our clients interact with our lawyer colleagues about. And so getting to the front lines of a lot of client interactions is through what's going on in real estate. Market trends have been a bit bizarre over the last year. The regular ebb and flow of transactional work has gone out the window entirely. Some of that is market-based, some of that is interest rate-based, and some of it is cost effectiveness, of which there is none. Some economists are suggesting that for Canada, the best thing would be for us to get to 2.5% by next summer. So whether or not the government, the Bank of Canada listens to economists, it's a crapshoot, but there is, given the current trends right now, a potential further downward pump in the rates for December. So fingers crossed and see how that goes. Personally speaking, the rate decrease that we just had actually has started to kickstart a few other projects and financial refinancings. So that's looking somewhat optimistic.
Can I ask a question on the rates? So previously, because the US Bank had lowered their rates more aggressively, then Canada followed suit, and it was anticipated that in December there was going to be another cut. But does the election result have an impact on that?
Well, the election result could have an impact on absolutely everything, so we can't always say what and how. But if you take the US out of the equation, Canada's rate decrease has been focused on what the Canadian economy has been doing. And right now, in order to match inflation, we're actually already there. We're actually hovering where we need to be. And so there's going to be this push and pull over the next 4 to 6 months, just on the Canadian side, just to stabilize our economy based on inflation and cost of goods and whatever it happens to be. Yes, the American situation will have an impact on how that plays out or how drastic, but the rate cuts that Canada has had are significantly deeper than the rate cuts that the US has been experiencing. And so there's a little bit of, what happened in 2008 when Canada decided to do its own thing and was the envy of the world for a while. Maybe that's going to play back into it so that there's not a direct cause and effect with the American election.
Thank you.
A few other things is that how we move money is going to be a major issue and concern. You think it's relatively straightforward, it's layered in complications. The more or less traditional way over the last 20, 30 years has been to move money, close transactions with a deposit of a bank draft or a certified check into trust accounts. Lo and behold, banks don't like checks and they don't like bank drafts. And so this is creating a large uncertainty in how money is moved and the security by which money is deposited, used, and relied upon. Increasingly, banks are, and I say banks, but it's any financial institution, it could be a credit union, it could be whatever, are recalling funds after they've been negotiated or deposited. And that uncertainty is causing a lot of concerns. So increasingly over the next little while, there will be more advocacy and more opportunities to try and bridge the gap between the Banking Association, the Payments Association, potentially OREA on their form of agreements of purchase and sale that tries to align this notion of how we're moving money. And particularly from a lawyering perspective, is the difficulty and challenges that we have with the liability of not moving the money in a quick enough way or an uncertain way. So for example, wiring is a guaranteed way of transferring funds, but it takes a long time and the uncertainty of point A to point B complicates things, and so lawyers like we do will regress back to comfort and familiarity depositing funds with a certified check. In the course of that, we may have a situation, and you're seeing more cases come out about this, where the funds have been wired and initiated, but they actually don't land in the receiving lawyer's trust account until after the closing date has arisen. And now we're starting to see more and more, maybe 3 or 4 cases at various levels dealing with time is of the essence. And that interplay between time is of the essence, full and complete closure, the movement of funds, keys, delivery, tendering, and all of these fun things are coming back in. What doesn't help is that the market is ridiculous. And when the market does things like this, more and more people will litigate over these issues, and you start to see more cases coming forward about, well, you didn't close on time. Well, yeah, but you didn't tender. Oh, maybe I didn't have to tender. And, litigators get their pound of flesh. So keep in mind that time is of the essence is still a thing, and the courts are grappling with that notion as we speak. The Director of Titles has issued a bulletin. I mentioned this the last time. I really think that it's an important segue for real estate practitioners to interface and integrate with litigators. The bulletin on court orders is something that everybody should be familiar with. It essentially is a very appropriate condition to getting a court order issued that's going to impact real property, if it's going to be registered on real property. From the real estate perspective, go out and make friends with litigators and explain how you can be part of that process. Getting the registry office to pre-approve the form of order, whether it's a construction lien, whether it's a vesting order, whether it's an amendment to title, whether it's anything under the sun, and it would impact anybody who goes to court for a remedy that has an impact on real property. Get the registry office to pre-approve it. They are very specific about what they want and need. What we're seeing increasingly is that the registry office will simply not put into practice what the court order has said if it isn't expressly clear as to what it's supposed to do. And that can get very frustrating, and usually it means getting it back into court, amending the order, and nobody really wants to do that, particularly if you felt like you have this resolution all queued up with consents, and now you're ready to go back to the court. So use it as an opportunity to market your abilities and to integrate with litigation. A strong plug again for the working group, the lawyers' working group on real estate, their fee schedule. Take a look at it, encourage it, broadcast it amongst your membership. Refer to it. There's a great website, and in that are several tools to help set appropriate fees for real estate purchases, sales, and refinancing transactions, largely in a residential context. But what it does is it starts the opportunity to ensure that you're actually looking at getting appropriate cost recovery from your fees, the time that you're putting into these transactions. There's no such thing as a cookie-cutter real estate transaction anymore. Every single one has a different implication. The risks are astronomical. The liability is crazy. It lands on the lawyer's shoulders. If you are in a firm, that attaches to everybody else that's in the firm. So go to the website, look at it. Encourage you to use their standardized documents. They're very tight. They're very appropriate. And they are also endorsed by all of our law associations. So continue to look at that. The provincial government has concluded a consultation process for a 10-day rescission period for freehold homes, newly built freehold homes. So that already exists for condominium units that are newly built, a 10-day rescission period to walk away. That looks like it is coming. We don't have any indication as to when, but it's probably going to be by the spring. The CRA's trust reporting requirements and the zaniness associated with that and the backpedaling, until the dust settles, we don't really know. That hasn't been formally adopted by legislation, but the expectation is we're probably okay for the most bit into 2025. In 2025, the trust reporting obligations will kick back in with more broader exemptions and exceptions, some of which will help us out, some of which will still require us to do reports. Bare trusts are still going to be reportable in certain circumstances. So stay tuned for how those are going to play out provincially. A lot of cases are still coming forward on HST problems, HST implications. Is your contract including it, excluding it? And another case recently on the situation of Airbnb. So it looked like a residential transaction. Airbnb rentals, for short-term rentals, that attracts HST liability. The lawyer didn't ask the question. Guess who's responsible for HST? Hard tokens are being extinguished and retired for access to EREG. Most people will have them on their phone as a digital token. If you or anybody in your association still has the dinosaur version of a hard token, they're not going to be able to practice for very much longer. November is Make a Wills Month, so make your will and broadcast that to your clients as well. And most importantly is to keep the communication going. I'd like to hear more and more from you, your organizations, and the real estate practitioners in your associations about what's impacting them, what's affecting them, the technology that they're using, the technology that they're not using, if they have enough supports, if they have clerks, if they have associates, if they have students, and how to better equip real estate practice into the next few years. AI is coming. It's not necessarily a target of how real estate is going to practice and function, but I can guarantee you that AI is going to impact all the tech that is around the real estate interface. And being on top of that is obviously going to be the wave of the future. Thank you.
I have a question.
No family court.
Now, this might be a pet peeve of my own as a family law lawyer, but because I haven't done real estate in many years, but what I discovered is that if clients that are separated decide to sell the house before they settle all their issues, and the proceeds will be held by the real estate lawyers in trust, I've discovered that there are some law firms that will charge a monthly amount or percentage for each month that they hold the proceeds in trust, which I've never heard of before. Is that a standard thing now in the real estate practice, to charge people for holding their money?
So I can't speak as to a standard of practice. From a real estate practitioner's perspective, way to go. I think that's probably the way to do it. I've heard a lot of that happening, particularly in that context. There's a couple of issues for it. One is there's no understanding or guarantee about how long that's going to be held in trust. So potentially you could be holding that for years and years and years. And so there's an issue with that. The other part is the administration relating to the holding of funds in trust, whether it's in an interest-bearing account, whether it's in your mixed trust account, whether it happens to be, those are going to be factors in there as well. So you're increasingly seeing the use of trust accounts becoming a fundamental shift in not only how lawyers are doing it, but certain types of lawyers, whether they're family lawyers, whether they're real estate lawyers, whether they're corporate lawyers. You're even looking at real estate agents that are not trying to use their own trust accounts. They're actually trying to put initial deposits right into the lawyer's trust account so that they don't have to worry about the administration as well. And what comes with that? Reporting on the interest, T5s, ID verification, reporting to FinTrack, monitoring the deposit, monitoring who's entitled to the deposit. If you don't know who's entitled to the deposit, you need a court order to figure that out. Those are called headaches. And usually there's going to be a fee associated with it. So while I don't see that as a standard, I see it increasingly as the lawyers starting to acknowledge that there should be a price associated with that maintenance, that responsibility, and that obligation to monitor those things.
Well, and I think in the family law context, like, our clients call and bother the real estate lawyers constantly, and arguably they don't get paid for that. So I get it. All right, we were told to hurry up.
Yeah, buckle up for Terry Brennan. Thank
you, Terry.
Buckle up. Thank you very much for that introduction. They put me last because I get 6 minutes out of the 35. So I have to go very, very quickly. Some of you know a great deal about legal aid. Some of you don't. First, I want to start, and we already saw the family law practitioners raise their hands. I'd like to start. Anybody do immigration and refugee using legal aid certificates? Probably no one, but maybe someone. Anyone? No? Okay, thank you. Criminal law. Any criminal law practitioners? Put those hands high. There you are, there you are. Legal aid, are you using legal aid? Any of those? Okay, and the family law people in the room who raised their hands earlier, only put your hand up if you're still willing to work on legal aid and you're actively using legal aid. So a lot less hands than we saw earlier. And this is the issue, sustainability of legal aid. It's sustainability of those willing to join the panel, whether you're a young new lawyer or whether you're senior counsel. Are you willing to stay with the legal aid plan? I thank Ian for what he said earlier to all of you about the concept in Alberta of just canceling legal aid. And I also wish to apologize, I couldn't be here at the spring plenary, and I thank Ian as well for filling in for me in the spring. We have an opportunity right now for all of the associations to appoint someone who will join the Legal Aid Committee. I'm the chair of the committee, but I need a province-wide committee right now. We have been called upon and tasked to assist the Alliance for the Sustainability of Legal Aid. That is an organization that FOLA attends as one of the stakeholders. The stakeholders, so that you're aware of what this association consists of. There are members from the Advocates Society, the Criminal Lawyers Association, the Family Lawyers Association, the Refugee Lawyers Association, the Association of Community Legal Clinics of Ontario, the Ontario Bar Association, Mental Health Legal Committee, and the Law Society. We are part of that group. We are part of that team. The last couple of years, we have seen an increase on our certificate side. We hadn't seen an increase in 25 years? At least it was something, it seemed to appease most of us, and we were content. Our overhead went up, our staff costs, everything, and now we got a little more, a little bit more. But there's money. Right now, there is money. The problem with legal aid is we don't have stable funding. By receiving funding from the Law Foundation with interest rates, there could be lots of money or there could be less money. How do you sustain a system not knowing what your budget is? And then we rewrote LASA in 2020. We have MEG. MEG right now is not really connecting with us. Historically, very good lines of communication. Maybe it has to do with the election coming up next year, maybe not. But the bottom line is ASLA is inviting us to help with the sustainability of legal aid. How will that work? You appoint a member from your board who will come to a meeting at ASLA by Zoom, and we will all be educated about the goals and what this will be dealing with. You will be tasked to lobby at a local level, your member of provincial parliament. We want to come from the bottom up to the chain, to the top, because right now we had communication at the top and we're not connecting. So how better to do it than through the associations? I'm watching the clock, I've got 2 minutes. I'm keenly asking you to go back to your boards and find someone on the board who does legal aid work or has done legal aid work, so they have a working knowledge and a vested interest so they can move forward and lobby locally. And you will be part of all of these stakeholder groups. I can tell you, I'm actually, on your behalf, part of the initial lobbying committee that helped to sort and design a model to address this issue of sustainability and funding. We had meetings October 1, October 8, October 15. This is very, very fresh. The next meeting, December 2. So there's your target. This is your month. If you could please write back to us. You've already received an email. Don't just ignore it. Don't just let it go to the side. We keenly and actively need you to go back at your next board meeting. We need that person assigned. We won't be able to get our hands out there on the pulse through the whole province without your help. Years ago, we were calling and organized a similar committee That was when there was talk of a potential strike. We're not there right now. Let's not have to go back that way. Let's act now with a good lobby for the sustainability of legal aid. For those who want to know more about the inner workings of legal aid, I didn't have time to give the background and the model. Just talk to me privately at any point. Thank you. 10 o'clock. Oh, and I wrote down to myself, any questions from Kathy?
Okay.
Yes,
I
Kathy.
don't know whether you've actually looked into this issue or not, so I thought I'd raise it. Ever since the pandemic, or ever since Doug Ford reduced the legal aid budget way back when, in family law, there are no duty counsel in Superior Court. So, for example, in the Milton Courthouse, there are duty counsels sitting around doing all their hard work in the OCJ wing, nothing in Superior Court. And I can tell you that our Superior Court judges, particularly like Justice Coates, get very, very frustrated about that because people who need legal aid don't just go to OCJ, they also go to SCJ for odd reasons, and they can't get any help. And because of that, the judges sometimes don't know what to do to try to get them help.
Kathy, I know it's the same situation throughout the province from what I've heard.
So is there a way to lobby to try to get duty counsel back into Superior Court?
I can tell you that they always talk about getting into the weeds. We're not really down there dealing with those issues. We're trying to deal with more of the let's get the money in, and then that's a matter of infrastructure. I hear what you're saying, but our discussions don't go down into that level, and rather we're looking at budgets and trying to finance, hire. I know, I'm being told to wrap it up. So yeah, I landed at 10 o'clock, it's 10:01. Kathy, talk to me privately, and anyone else who wants to join, please join. Thank you.
Thanks, everyone.
Thanks, everyone.
I think we're headed into a brief break within the next 9 minutes or so, if you needed to refresh your coffee or other things. Thanks.
What is that?